Hi everyone, this is Hamita. Welcome to Safavi Law Channel. Today's topic it is relating to vicarious liability. Before we have discussed about that what is no fault liability and how it's described like a strict liability, absolute liability, and vicarious liability. So strict and absolute liability in the previous sessions we have covered. Now today's topic it is relating to the vicarious liability. Vicarious means what? Vicarious it is what? It is a Latin term in the sense indirect or alternative. The vicarious in the sense what? Indirect or alternative. Suppose if someone committed any tortious act, then directly that person only liable. Means if I committed any tortious act, directly I will be liable and I'll have to give the compensation to the victim party, right? But in some situations, without the fault, without the negligence, indirectly the other party will be liable. Such kind of liability is called vicarious liability. Okay, so here vicarious liabilities are classified into four parts. That is, first one is the principal. They have some relationships in between the two parties. That is the principal and agent relationship. Second one is the partner and partner relationship. Third one it is the master and servant relationship. And again, the last one it is the state and the servant relationship. Means if these two parties have some relationship, then that liability arises. Without any relationship, that liability will not be arises. Whoever the committed tortious act, that party only liable of the particular tortious act, and they will give the compensation to the victim party. Okay, now we will go to the liability of the principal for the tort of his agent. Liability of the principal for the tort of his agent means if the agent committed any tortious act, who the liability creates to the principal means the principal will be liable. Second one, liability of the partner for the tort of each other means if one partner committed any tortious act, the another partner liable. Again, liability of the master for the tort of the servant means it is related to general. If servant committed any tortious act, then the master will be liable. Again, liability of the state for the tort of his servant. In the sense, if suppose if the public servant is committed any tortious act, then the state will be liable. So here in all the four categories, they have some relationship. Okay, if they have relationship, then only the master will be liable. Okay, so now we will go to the first who is servant, who is master, who is independent contract definitions. So this first we will go to the these all are the definitions. Servant means who? Servant means a person who takes the salary from the master and who is under the control and directions of the master. Whatever the act committed, that person is called the servant. Means a person who takes the salary. Okay, monthly, if the master who gives the salary to the servant. Again, if the master, in the sense the employer who shows some directions to the servant, you have to do this work, you have to do that work. If you have to show some of the directions to the servant, along with that some control to that servant means just you have to do this work only, otherwise you will be liable. These all are the things what under the control of the master is the servant doing some work, and that person is called a servant. Okay, now we will go to the who is the master. Master means a person who gives the salary and who shows the way, in the sense who controls to the servant and who gives some directions to the servant. That person is called the master. Now we will go to the who is the independent contractor. So we know that servant in the sense a person who takes the salary from the master, that person is called the servant. Now independent contract in the sense not under the control of the master, even not with the directions of whatever the work committed by the independent, not with the directions of the employer or the master, without any salary means independently whatever the act, whatever the work committed while doing of that particular work, if any tortious act happened, then master is not liable. Then who will be liable? Independent contractor only liable, because of that master is not giving the salary to the independent contractor. Even the master is not controlled to that independent contractor. That's why if the independent contractor committed any tortious act, that person is an independent contractor only liable. Okay, so these things that in the definition part clearly described. Now we will go to that the essential elements of the vicarious liability. Here the vicarious liability divided into two categories. That is the tortious act must be committed by the servant. and that the tortious act must be committed in the course of the employment. Okay, first one it is the tortious act committed by the servant. Means who committed the tortious act? The servant committed the tortious act. Second one, in the course of the employment, the tortious act committed in the course of the employment. What is the in the course of employment? Means employer in the master who gives the work to the servant, some work, and they also mention some timing. Okay, suppose if the master who mentioned the time that actually when we see about the office timing is from the 10 to 5 or 9 to 3, some 6 hours time we generally we use that. So during that time, given that the servant who is doing under the control and under the directions of the master, okay, while doing of that master's work, master's office works only, if any tortious act happened, then that master is liable, not the outside the course of the employment. Suppose if the servant committed at the night time for his personal work, not it is connecting to the office work, I mean outside the course of the work, if they committed any tortious act, then how that master is liable? The master will not be liable. Master only liable if the servant committed in the course of the employment of the time. So during that period, during and whatever the work is connecting to the master's work, means office work, or whatever the work is relating to the master work, then only the master liable of the tortious act of the servant. Okay, so here clearly that when I see just I highlight that particular thing in the course of the employment. So in the course of the employment is one of the essential element of the vicarious liability. Yeah, here in the course of the employment also divided into 3 categories, that is the authorized act and the natural consequences, unauthorized mode of doing authorized act, and the incidental act. So here is in the course of the employment. In the course of the employment, it is one of the essential element of the vicarious liability. This one is also divided into 3 categories. That is the first one, authorized act in the natural consequences. What is the authorized act in the natural consequences? Authorized in the sense what? Master who authorizes some work to the servant. Means the master who gives some work to the servant. Okay. So while doing whatever the work authorized by the master to the servant committed an authorized way only. While doing of that, some natural consequences happen. If some any tortious act happened by the servant, then also the master is liable. Okay, now we will go to the next way. One of the essential element of the in the course of the employment, that is the unauthorized mode of doing authorized act. Firstly, authorized act, whatever the authorized work given by the master to the servant, and the servant also committed in the authorized way, but some negligence, some kind of some incidentally or some accidentally, if something happened, then that the master is liable. Then if the servant committed unauthorized mode, in the sense unlawful mode, unauthorized mode, like carelessly, negligently, fraudulently, willfully, if they committed, whether the master is liable or not? Yes. Here also might be the servant committed in unauthorized mode only, but still the master is liable. Now we will go to the few of the unauthorized modes. That is the first one is the carelessness of the servant. Carelessness of the servant. If the servant is carelessly, if they committed any tortious act, might be if they negligently, carelessly, whatever the act committed, still the master is liable. Now we will see about one of the case law, that is the Century Insurance Company Limited versus Northern Ireland. Here in this case, the defendant servant who struck the match for lighting of the cigarette and threw the stick on the floor while transferring of the petrol from the underground to the lorry. So while doing our transferring from the underground to the lorry, that explosion happened, and that complete the property of the plaintiff destroyed. So this is what carelessness happened. Carelessness of the defendant happened. Defendant servants happened, not the defendant. The defendant servants happened. So still, whatever the work tortious act committed by the defendant servant only, but still the master in the defendant only liable of the. That means the defendant only have to give the compensation to the plaintiff party. Is it clear? Now we will go to the willful wrong of the servant. Willful wrong of means This willfully, if wantedly, if that servant committed any tortious act, still the master only liable. Now we will go to the one of the case, this relating to the Limpus versus London General Omnibus. Limpus versus London General Omnibus. Here, that the owner of the omnibus who have instructed to the drivers not to drive fastly and not to overtake the bus from with the other buses. Many of the instructions has given to the driver, not given the instructions to the driver. So here the driver willfully, wantedly overtake the bus and got the accident. For that, the plaintiff who injured and who filed the suit against to the defendant. So who will be liable here? Not the driver, only the defendant only. That means master of that particular vehicle. In the sense, the owner of that vehicle only liable. So such liability is called the vicarious liability. It is also one of the whatever the act committed, it is one of the unauthorized mode of act committed by the master, committed by the servant, so that master only liable of the tortious act, whatever the act committed by the servant. Now we will go to the one of the unauthorized mode, that is the fraud of servant. Fraud of servant means if carelessly happened, if willfully committed, then okay, it may be considered. But in some case, fraudulently, for the benefit of the servant, if any act committed, for that either it may be related to money, either it is related to whatever it may be, it is for the benefit of that servant, if they committed, then how the master is liable? Whatever the act committed for the benefit of the servant only, if the plaintiff suffered something, if the plaintiff suffered loss, then also the master only liable. Now we will go to this is relating to the one of the case, that is the Lloyd versus Grace Smith and Company. Lloyd versus Grace Smith Company. In this, Mrs. Lloyd, who had two houses, and she was not satisfied with that two houses. She wanted to sell the property. She went to the Grace Smith Company, and one of the clerk of the Grace Smith Company who has given the who has advised to the Mrs. Lloyd to sell that property and bring the whatever the documents relating to that property. Then he changed that particular property from the sale deed to the gift deed on his clerk's name, without informing to the principal, without the knowledge of the principal, who changed the property on the name of the clerk. So this one fraudulently who changed that name. So here the Lloyd who filed a suit against to that particular company. So here also, if this benefit is happened to the clerk only, but still the master only liable. So whatever the act might be the master not given any salary or doing of any other activity, that is the secondary. But still, if they happen in tortious act, means if while in the particular employment only it will be happen in the sense what, then also the master only liable of the tortious act. Now we will go to the next unauthorized mode, that is the negligent delegation of authority by the servant. Negligent delegation of authority by the servant. Here one of the case law mentioned, that is the Vicarious Lal versus Surinder Singh. Vicarious Lal versus Surinder Singh. In this case, the defendant driver who has given the steering to the cleaner. The defendant driver who has given the steering to the cleaner with the negligence of that cleaner who got that accident, the plaintiff who got the various injuries. So here who will be liable? The master only liable. Master is the owner of the vehicle only liable, not that driver who has authorized, who has delegated the power to the cleaner. Not that person. Means the main owner of that particular vehicle, that owner only liable. So that's why it is also one of the unauthorized mode of this delegation of the authority by the servant. Okay, now we will go to the theft by the servant. Actually, theft by the servant is not considered as connecting to that vicarious liability. Later on, this one theft is also considered as one of the essential element, one of the thing, one of the unauthorized mode of thing. Then also this is considered as a vicarious liability. So first we will go with the case, that is the Morris versus C.W. Martin and Sons and Limited. So here in this case, the plaintiff who has given the fur coat to the defendant's company for the dry cleaning of that particular fur coat. Instead of cleaning of that coat, the one of the servant of that particular company who stolen that fur coat. So here, stolen a theft happened. Who will be liable? In this case also, master only liable. Okay. Now we will go to the express prohibition. Express prohibition is expressly they prohibited. Yes, you don't have to do this work, that work. Prohibition of the work. If the master prohibited, but still servant is committed any tortious act, then also master only liable. Because of these, all of the things happen during the course of the employment. In the course of the employment only happen. So says that Olympus versus London general omnibus, same case what we have discussed in the previous session, means in the sense what here the master said to not to overtake the bus, not to drive fastly or rashly. So many instructions, many expressly they prohibited something, but still the servant committed and the tortious act happened. But then also the master will be liable. Is it clear? So whatever it may be, whether it may be express prohibition or might be the master who gives some instructions or some direction, but if without that following of that particular instructions, the servant committed any tortious act, and then during of that course of employment only it happened, then also the master only liable. Is it clear? So now we'll go to the lending servant. Lending servant is lending borrowing servant from the another's office. Suppose here two employers are there, employer 1 and employer 2. So employer 2 who borrowed the servant from the employer 1, and that whatever the act whatever the work given by the employer to that particular servant, and that the particular servant committed the tortious act, who will be liable, whether the first master or the second master? Here in this case, according to the Messi docs and Coggins case clearly described, who is the main owner who is giving the salary to that servant, that owner only liable, not the second owner. Second owner is not giving any salary or and all the directions to that particular servant, but that the first employer, because of the first employer only who is giving the salary to the servant, who is showing that directions and controlling to that particular servant, means that particular first master only liable, whether it may be the lending, the borrowing to the servant. Okay, so these all of the things has described, which comes under the unauthorized mode of way. Okay. Now, here that particular case also have some of the exception, that is the outside of the course of the employment, lending of the servant, employment under the compulsion, doctrine of the common employment. So here the unauthorized mode, we have some of the exceptions are there. In unauthorized mode, we have some of the exceptions, that is outside of the course of the employment. Outside the course of the employment, in the sense what I just now I said, during the course of the employment, if they committed, then master is liable. Outside the course of the employment, if the servant committed any tortious act, how the master is liable? So suppose if might be if not in the during the period of that particular time, for the personal, whatever the work committed for his personal work, okay, not it is connecting to the office work, not is connecting to the employer's work, personal work committed, and again tortious act committed by the servant, the master is not liable because it is connecting to the outside of the course of the employment. Is it clear? So now the lending of the servant, just now I said, borrowed that servant from the another's master. If this servant committed any tortious, the first master only liable. So this is also one of the exceptions of the vicarious liability. Now we will go to the employment under compulsion. So whatever that employment happened under the compulsion, not with the free will by the employer, or with the salary or directions of the employer happened, with the compulsion, in the sense the employer, whatever the employment happened with the compulsion, then also the master is not liable. Next one, doctrine of common employment. Doctrine of common employment. Common employment in the sense of common, jointly. If the injured party and the whatever the servant, whoever the committed the torture, both are the same. Both are in the sense what the servant, whatever the tortious act committed, and that servant only who received the injury, means injured party as well as that the particular person, that the servant, both are the same person. Then that if any tortious act happens, then that master is not liable. This is also comes under the one of the exception. Is it clear? Now again we will go to the employer and the independent contractor. Employer and the independent contractor. Employer in the sense I just said, the person, employer in the sense the master who gives the salary to the servant and who controls to the servant and who shows the directions to the servant is called as employer or the master, right? Independent contractor in the sense what? Without the salary, without under the direction, without the control of the master, whatever the work committed, that party comes under the independent contractor, right? So here, how these people will be liable? So here, one of the case, that is the Morgan versus Incorporated Central Council. Here, in this case, what happened? Here, the employer who has given that work to the independent contractor to manage the lift, with the negligence of the independent contractor, some defaults happened into the lift, and one of the plaintiff fell down from the lift with that particular lift was open at that time. So here the plaintiff who received the injuries and who filed the suit against to the employer, that then the court held that the employer is not liable because of that lift who is in the management of the independent contractor, not the management of the employer. So here independent contractor only liable. Is it clear? So here that some of the this for that independent contractor also few exceptions they describe, that is the illegal and unlawful act, personal fault of the employer's statutory duty. First, illegal and unlawful act. Suppose if that employer who gives whatever the work to the independent contractor, if any unlawful act if they give, then that the independent contractor is not liable. Employer only the liable. But if the legal work, suppose managing that management of that particular lift, in this is what legal act. So here the independent contractor has to manage that lift properly, right? So this is what legal work, legal activity only. But if that employer who gives some work, that work is relating to the unlawful or illegal work, then that independent contractor is not liable. Then the master only, in the sense employer only liable. Now coming to the personal fault of the employer. If that employer's fault only happens, then that the independent contractor is not liable. Employer only liable because of that fault happened by the employer only. Now statutory duty. If the statutory duty is relating to statutory duty, means if the statute who gives some work to the independent contractor, if any tortious act happen, then the statutory authority will be liable. So the statutory authority also, if any independent contractor or if any tortious act happened by the independent contractor, then that this employer is liable if it is related to statutory duty. Okay, so these all are the essential elements which we can discuss about the unauthorized mode. Now the third one is the incidental act. So incidental act, when it will be happen, means if someone this the master who gives some of the work, while doing of the work incidentally, this accidentally some tortious act happened with that servant. If any tortious act happened with the servant incidentally, this accidentally happened, still master is liable. Is it clear? So these all are the essential elements. Suppose it might be the act, whatever the tortious act might be negligently, carelessly, or fraudulently, intentionally, if they committed, still that master only liable. Or if without that intention, without any carelessness, but while doing of that incidentally, accidentally happened, they're also master only liable. Why? Because of they have some kind of relationship. That relationship, it should be in the course of the employment, and that relationship not the outside course of the employment. So when they have in the course of the employment, because of the employer who gives that salary to the servant and who controls to the servant, who is showing the directions to the servant. So if any incidents happen, if any tortious act happen with the servant, then that master is liable. So this is about the vicarious liability, and this is about the various relationship between the masters and servants relationship. Is it clear? I think this topic, no fault liability, easily you can understand about all the topics, whether it may be related to strict liability, absolute liability, and vicarious liability. Thanks.